you want to do, Ms. Newton?
Yes, Your Honor.
You had enough time to think about this?
Yes.
Okay. You have any questions at all? Okay, I'm going to go through your rights with you. If you do have any questions, speak right up and let me know. But also, anytime you want to talk privately with Attorney Brooks, feel free to do so as well, okay? Understand, you don't have to plead guilty today if you don't want to. You do have the right to enter and continue with a not guilty plea and eventually to have a trial if that's what you want. You understand you have that right.
Yes.
You also have what we refer to as the right to remain silent, meaning you couldn't be forced to testify or give evidence against yourself, and you have the right to be represented by an attorney throughout these proceedings, but you'd have to make your own arrangements for one. Do you understand that?
Yes.
If you continued with your not guilty plea, you'd be entitled to a trial. You could have a trial either in front of a 12-person jury or just in front of a judge. That would be your decision to make, but at any trial, the state would have to prove you guilty by beyond a reasonable doubt. And at a jury trial, all 12 jurors would have to unanimously agree on the verdict. Understand that you have those rights.
Yes.
At a trial, you would have the right to hear and see what the state's witnesses had to say. If you had a lawyer, your lawyer could question the state's witnesses. If you were representing yourself, you could question the state's witnesses. Also, you could call witnesses to come to court to testify for your side. And if for any reason any of your witnesses did not want to come to court voluntarily, through your attorney, you could make sure they came to court and testified by having the court issue a piece of paper called a subpoena to those witnesses. Then they would have to come to court and testify. Do you understand that you have those rights as well?
Yes.
At a trial, you would have the right to testify like any other witness, but as the defendant, you'd also have the right not to testify. And if you decided not to testify, then you wouldn't have to testify. You couldn't be forced to testify, and it could not be held against you in any way if you decided not to testify. Do you understand that you have that right?
Yes.
Also, you'd have the right to appeal any verdict to a higher court. In Vermont, that court's called the Vermont Supreme Court. You understand that you have that appeal right?
Yes.
Any questions at all, Ms. Newton, about any of these rights that I've gone over with you? Now, do you understand if you do plead no contest, that you'll be giving up your right to a trial because you'll be giving up these rights that I've gone over with you because there'll be no further trial in your case?
Yes.
Has anyone used any force or made any threats against you to get you to go along with this agreement?
No.
Has anyone made any promises to you to get you to do this other than what we've discussed today on the record?
No.
Are you doing this today voluntarily?
Yes.
I need to ask, are you currently under the influence of alcohol, drugs, or prescription medications such that you do not understand these proceedings here today? I need to tell you that if you are not a U.S. citizen, this agreement could result in your deportation, denial of U.S. citizenship, or denial of re-entry into the country. That only applies if you're not a U.S. citizen, but you understand that. The maximum potential penalty for the charge of driving under the influence first offense is a term of imprisonment of not more than 2 years or a fine of not more than $750 or both. Do you understand that?
Yes.
And the nature of the charge is that at Rutland City on or about February 4, 2026, you were driving a motor vehicle on a public highway while under the influence of alcohol. That's the nature of the charge. Do you understand that? And do you understand that by entering a nolo contendere plea, you're not contesting that if this case went to trial, the state could prove that you were driving a motor vehicle on Door Drive in Rutland under the influence of alcohol. You're not contesting the state could prove that to a jury by beyond a reasonable doubt. Do you understand that?
Yes.
The charge of driving under the influence first offense, what plea would you like to enter at this time?
No contest.
Right, court will accept your no contest plea, find that there is a factual basis. Court will find that you've made your plea knowingly and voluntarily with full knowledge of the consequences and that you've waived your constitutional rights. The court will enter adjudication of guilt in this matter. You're welcome. Anything further from the state?
I have nothing further.
Attorney Brooks.
Just that Miss Newton is accepting responsibility very early on. She has learned a lesson from this. She's really taken it to heart, and she's grateful that nobody was hurt.
Fair enough. Ms. Newton, anything you wish to tell me before I impose a sentence? Okay, well, you're a very young person. You made a mistake, but the good thing is you're here taking responsibility and you're going to learn from it and make sure this doesn't happen again. So court will accept this agreement, fine you $300 plus the required surcharges. You're all set?
Thank you.
Good luck. You need to have you check in at the downstairs window. They'll talk to you about the fine and surcharges.
Thank you.
Thank you. Okay, thank you, Attorney Brooks. I have one more, but I don't think he's here. State versus Stephen Williams, 26 CR 1743, one count aggravated operation without owner's consent. There are already 2 arrest warrants out for the defendant. Looking for, just in case, check the hallway for Stephen Williams.
This is most certainly a conflict for
Yeah.
the defender.
Yeah.
He's the co-defendant for the Madison case.
Yes.
I heard he was still in New York awaiting extradition to Vermont.
Okay.
What's the last name there?
Williams. Yeah, that's my recollection as well. But in any event, he's got a citation to appear in court today. Citation actually says
Yeah. Yeah, been there. No. Well, come on, Harriet. What's going on with this? Hello? Did you do? You need to know. Hello?
Gosh,
Hello?
I was just making sure my mic was working. I'm muting it now, though.
Okay. Yeah. Yeah. Real five.
Hey, Justine, it's Attorney Hart. Are you available for a second?
That is in it.
Oh, is that right?
Kill and a half.
Huh?
Kill and a half.
No, sure that would.
I just let it down. So he's in it.
It's upstairs.
Yeah.
Thank you. You may be seated.
We're good with it.
I found it. Don't worry about it.
Good afternoon, everyone. We're on the record now. This is Judge Corsones, ready to start our 3 o'clock status conference block, and I'm going to take the cases up once again in alphabetical order. If you do have a conflict such that you need to leave sooner, speak up and let me know. Also, if you're an attorney and you just have one case, it's okay to speak up and let me know. We can take that up sooner. In addition, you're got a client here in the courtroom and you want to go sooner, that's fine as well. So, and if you're self-represented and you just have one case and you want to go, that's okay. So with that, any special requests before I start at the top of the list in alphabetical order? Okay, first case is State versus Tracy Benoit, 24 CR 9494. Mr. Benoit is
802-342-25.
Thank you. Write that down.
Planning to JA supervising it with multiple.
Okay. There it is. Oh, here we go.
Over here or.
So, we recently assigned Attorney Enzor to your case.
Okay.
There's his name and his phone number. The best way to reach him is to text him.
Okay.
If you don't mind, just send him a text, tell him who you are, and he's been assigned to represent you.
All right.
And we're going to reschedule this hearing for another 30 days or so.
Okay.
Okay, Attorney Walco?
Yes, Judge.
Okay. You're all set.
Thank you.
You're welcome. I don't know how many cases he has. If it becomes a problem, we'll deal with it. The next case is State versus Mitchell Bowen Jr., 1396-1218, RDCR 22 CR 10490 81220, RDCR 1813, RDCR 25 CR 405. The last one is the new criminal charge. Defendant is represented by Attorney Bergman. Attorney Raleigh represents the state. My last note. So we had a status conference on December 15th. Attorney Bergman is new attorney to the case. He's now reviewed the discovery. Parties have exchanged some preliminary offers. Still need to depose the complainant, reset for status conference in 60 days. Attorney Bergman, where do we stand with Mr. Bowen?
I was able to depose the complainant, and so I have provided Attorney Raleigh with potential resolution, waiting to hear back on that. I also, in light of the deposition, am exploring whether I need an expert witness in my case. So I'm actively dealing with that. And then so there's 4 VOPs. The last 2 are related to the underlying, to this new case. The first 2 I requested discovery about a month ago on, and I'm still waiting to hear back.
Roy.
Yes, Judge. I don't think that we are likely to reach a resolution unless it is contested. And I'm happy to communicate with Attorney Bergman directly about that. So I think we need to go on a pretrial list, appreciating that there may be some defense exploration for an expert. I would pose May, unless that doesn't feasible. And I am following with the VOP discovery.
Think it's more than a one-day trial?
I don't,
Unless,
unless.
depending on the expert. Yeah.
Unless an expert turns out to be.
Yeah. Attorney Bergman, does a May pretrial and jury draw appear reasonable?
I think that would give me enough time, and I can file a continuance if I need to disclose an expert.
Okay. Okay, we will put it on the May pretrial and jury draw. Might it, I mean, certainly defendant's entitled to a pick and go. I don't know if we know yet if he wants a pick and go. Maybe we'll set, let's do a
I would
status
want,
conference.
yeah, I would
ahead.
want a pick and go.
Pick and go, okay. So it has to be a pick and go. We'll set it for status conference in April as well. Okay,
Very good.
thank you. State versus Clyde Bowles, 865-607 RDCR VOP status conference. Attorney Groff and Attorney Walco. You see a note, defendant's appearance is required and he may appear by WebEx. Oh, my last note from December 30th. This is a very old VOP. Defendant enters a denial. So we had the VOP Rule 5 hearing on December 30th. Bail is struck. Parties agree on an admission with discharge from probation, but state has to look into one thing. Set for status conference in 30 days with defendant's participation required. Remote appearance. Okay. Let's see. Attorney Groff, have we heard from Mr. Bowles?
I have not yet today, Judge. I suppose my request with this having been set for a status would be to go ahead and set this for a VOP merits and have him required to show up that day. I spoke with Attorney Walco or emailed back and forth with her, and she's still in agreement that is the plan. So that would be my request.
Okay, let me just double check. If Mr. Bowles is on the line, you need to speak up. Or if you're in the courtroom. Walco?
Yes, Judge. I believe we did have an agreement to admit and discharge. Obviously, we need Mr. Bowles for that. I'm fine with setting a merits hearing, that expectation.
Set it for a 15-minute VOP merits. Missy is required to attend. Versus Heather Kuravu, 25 CR 41 34 12134 12117 12032 11948 11772 11462 10851 9470 7685 7588 and 4135. Attorney Davis and Attorney Ferlin for Ms. Kuravu. Attorney Bevere for the state. Oh, I've got a note from February 13th. Defendant was unable to attend her competency evaluation on February 11th as she was hospitalized. She also did not attend her evaluation in January. Case is set for a status conference the 23rd. We'll need to review the situation. Attorney Davis.
That is all accurate. I spoke last week with Ms. Kuravu. I understand she is still receiving inpatient medical treatment.
Let me just see if that's, is Ms. Kuravu on the line? Somebody was trying to talk. Okay. Go ahead,
I didn't expect her to call in necessarily, so she's still inpatient. I did receive some information today about I think a case manager or someone working with her who may be able to facilitate the rescheduling of the evaluation, even if she remains receiving inpatient treatment for the time being. So that's very promising. It's not for lack of trying to get through this part of the process. She just made the appropriate decision under the circumstances in which she needed medical care. She went and got it. So I think we will need another court order. What I may do, what may make the most sense is for me to follow up with Dr. Donnelly and Cheryl at DMH, arrange a date and time, and then perhaps notify the court so that the court can reissue the order. I would be reluctant to do anything today because we don't know Dr. Donnelly's schedule. So I can do that and file something with the court once we've had an opportunity to nail down a follow-up date.
Attorney Bevere.
That's fine, Judge.
Ferlin?
I don't have anything to add, Your Honor.
Okay, makes sense. Let's set it for another status conference, 30 days out or so, so we've got something set. But the expectation is Attorney Davis will talk to people he's got to talk to and hopefully give us a date, and court will reorder a competency evaluation.
Understood.
Versus Matthew Falco, 24 CR 6590, on for a VOP status conference. Attorney Ferlin and Attorney Walco. No, doesn't not have a Bagans issue present. Attorney Ferlin, where do we stand on this VOP case?
So I have spoken to Mr. Falco once. I really feel like I need to do that again. But so I guess if we could set it out a ways for the merits, maybe 60 days, that'll give me time to see what I can accomplish.
Attorney Walco?
I have no objection to that, Judge.
Okay, set it for a 30-minute contested merits, no sooner than 60 days.
Thank you.
Yep, you're welcome. State versus Isaiah Hall Graham, 25 CR 11110, 11108, 10313, 5697, 5695, 4984, 4983, 4332, 3551, and 4946. We have Attorney Roth representing Mr. Hall Graham. We have Attorney Bevere representing the state. The defendant is incarcerated. My last note from December 30th, case was set for change of plea. However, parties do not have a complete agreement. They request April pretrial and jury draw with a status conference in February to see if there's an agreement. Attorney Groff, is there an agreement or keep it on for trial? What's the plan?
Judge, there is an agreement, I believe, as to every case except for 25 CR 11108. I believe that case we can go ahead and leave on for April pretrial and jury draw. If we happen to find a way to include it, we can do that. But otherwise, the other ones I think we can go ahead and set for a change of plea perhaps in March. That way we know whether or not we're ready to go in April.
Member here?
That's fine, Judge.
Okay, so 25 CR 11108 will remain on the April pretrial and jury draw. And the other cases will be set for a change of plea in March. And we should do a status on the other case as well at the same time. Okay, thank you. State versus Logan Irwin, 25 CR 6855, Attorney Brooks and Attorney Raleigh. So I've got a note from January 14th. Case came on for calendar call, set for status conference, and require his participation. The notices do not reflect that. Hey, Brooks.
So I know that there are still warrants already out
Yep.
there, Your Honor, so we're in the same spot.
Attorney Raleigh?
There is already an outstanding arrest warrant, Judge, in 12983. I will also note that it appears the only docket I'm actually assigned to is 06855. The other two are assigned to Attorney Walco. So if this could also be assigned to her, it'd be helpful.
Okay.
That I think we just wait for the arrest warrant to be executed.
We just put it in inactive status till he's picked up on arrest warrant. Okay, so we reassign it to Attorney Walco as well. Okay, so 25 CR 6855 will just put an inactive status till he's picked up on the arrest warrant in the other case.
And Your Honor, there is a flash site for this afternoon. Mr. Burnett, who is here, I don't know if we could take that up briefly.
Okay.
And this will need to be reassigned to conflict counsel, though I am able to handle it for purposes of this afternoon's arraignment.
Thank you. We're on the record. State versus Austin Burnett, 26 CR 1727. Mr. Burnett's here with Attorney Brooks, Attorney Walco for the state. We're here for an arraignment. Attorney Brooks.
Your Honor, we are in receipt of the one count information. Mr. Burnett would waive formal reading as well as all other Rule 5 warnings and formalities. He asked that a plea of not guilty be entered. It's my understanding from looking at the information that the state is just looking for release on his own recognizance, which obviously he would agree to.
Okay. All right. Be released on his own recognizance. We'll have to assign conflict counsel. State versus Michael Lee, 25 CR 13043 7201. Attorney Brooks and Attorney Ferland, Attorney Olson for the state. Oh, last notes from January 12th. Case came on for status conference based upon the new charge set for a further status conference. See who's got the older one. That's Attorney Ferland. Attorney Ferland, where do we stand on your case?
That case is in youthful offender status, Judge, in the juvenile court.
Okay. So 25 CR 7201 should be taken off our docket for now. And Attorney Brooks, how about your case?
Your Honor, I think that we need to submit an FSO at this point.
Can we give you enough time?
Yes, yes, sir.
Attorney Olson, 1 week for an FSO?
It's fine, Judge. Thank you.
Okay, very good. Thanks. State versus Matthew McCollum, 25 CR 13653 26 CS 14. Attorney LaChance here with Mr. McCollum, Attorney Bevere for the state. Attorney LaChance, where do things stand on this case?
Yes. So this is the first status conference scheduled post arraignment. I did briefly. Sorry,
Go ahead. That's just somebody speaking
okay.
on WebEx.
Had a chance to touch base with Attorney Bevere very briefly at the start of this hearing through email. We're going to connect later this week to, discuss the case.
Well, let's do this. Why don't you folks file a felony discovery order within 1 week?
That should work, Judge.
Okay, and if you reach a resolution or need further court's attention, let us know. Attorney Bevere, how's that sound?
That's fine. Thank you, Judge.
Okay, parties will file a felony discovery order within 1 week, and the court will follow it. Okay, thank you.
And just related, there is a civil suspension matter. For some reason, it's listed as the attorney of record, effective reflecting attorney of the year is handling that state.
Very good, we can do that.
Thank you, Judge.
State versus Lena McCurrier, 25 CR 1884. I have Attorney Hart for Ms. McCurrier and Attorney McCohen and Keene for the state. It's like we have Attorney McCohen
Good afternoon,
on
Judge.
WebEx. Good afternoon. We have Attorney Hart.
So Attorney Hart did email me. He is bouncing his work to approve. But he did say he
Hey, McCollum, you okay if we circle back to this one when we get Attorney Hart? Apparently he's in another court right now.
Yes, no problem. Thank you, Judge.
Okay, thank you. Okay, we'll come back to it. State versus Daniel McClellan, 25 CR 1299, Attorney Brooks and Attorney Raleigh. Mr. McClellan is present as well. I've got a note from February 2nd. Case came on for status conference. Parties have not filed a felony discovery order, but are very close to reaching an agreement set for status conference in 2 weeks. Court's in receipt of a notice of plea agreement, notice of potential collateral consequences. Is the thinking to do a change of plea and sentencing today? Or, oh no, PSI is to be ordered.
Yes.
Okay. We don't have to do a psychosexual or
No.
not? Okay.
We do not.
Okay. So we'll do a change of plea today, order a pre-sentence investigation and come back for a sentencing hearing.
Yes, Judge.
Okay. And would our usual half hour be enough time?
I suspect that it will be, I guess if it's, yes, I think a half an hour is fine.
Mary Brooks, think I have. Okay. All right. So, Mr. McClellan, I'm going to go over the agreement with you as well as your rights to make sure you understand everything, okay?
Yes, sir.
As I go through the process with you, if you have any questions, speak right up and let me know. But also, if you want to talk privately with Attorney Brooks at any time, feel free to do so.
Yes, sir.
Okay. According to this agreement, you're going to plead guilty in 25 CR 1299 to the charge of lewd and lascivious conduct with a child. As a result of that guilty plea, you will receive a sentence of 2 years to 8 years, all suspended, placed on probation. The term of probation to be until further order of the court, but for a minimum of 5 years. Do you understand all that okay?
Yes, sir.
And also there's certain standard and special conditions of probation that you will have to follow as well. Do you understand that?
Yes, sir.
And have you had enough time to go over all of the proposed probation conditions with your attorney?
Yes, sir.
I'm not going to go over each and every one, but they include that you be screened for any potential mental health issues, and that if the screening recommends treatment, you'll get the treatment.
Yes.
No contact except for electronic contact with.
It is worded a little
Yeah.
oddly, Your Honor.
Explain that one to me.
Sure, Your Honor. So there's to be no contact with both EE and AW, except there is an exception for AW with respect to electronic communication regarding FM.
Okay, thank you. No contact with females under 16 except for your own children. Not go to places where children congregate except with your own children and in the presence of another adult. Sex offender treatment, polygraph examination, sign necessary waivers to confirm attendance at treatment. As well as the other conditions that have been identified, that are, as well as other appropriate related conditions identified through the pre-sentence investigation process. Do you follow all that okay?
Yes.
Okay. And sex offender registration is required by law, 10 years post supervision. So far, so good? Any questions about the agreement itself?
No.
Now, do you understand you don't have to plead guilty today if you don't want to? You do have the right to continue with your not guilty plea and to have a trial if that's what you want. You understand you have that right.
I understand that.
You also have what we refer to as the right to remain silent, meaning you couldn't be forced to testify or give evidence against yourself, and you have the right to be represented by an attorney throughout these proceedings. And if you can't afford one, the state will provide you with an attorney. Do you understand that?
Yes, sir.
If you continued with your not guilty plea, you'd be entitled to a trial. You could have a trial either in front of a 12-person jury or just in front of a judge. That would be your decision to make, but at any trial, the state would have to prove you guilty by beyond a reasonable doubt. And at a jury trial, all 12 jurors would have to unanimously agree on the verdict. Do you understand that you have those rights?
I do.
At a trial, you'd have the right to hear and see what the state's witnesses had to say and to have your attorney question those witnesses. Also, you could call witnesses to come to court to testify for your side. And if for any reason any of your witnesses did not want to come to court voluntarily to testify through your attorney, you could make sure they came to court and testified by having the court issue a subpoena to those witnesses. Do you understand that?
Yes, sir.
At a trial, you could testify like any other witness, but as the defendant, you'd also have the right not to testify. And if you decided not to testify, then you wouldn't have to testify. You couldn't be forced to testify, and it could not be held against you in any way if you decided not to testify. Do you understand that?
Yes, sir.
Also, you could appeal any verdict to a higher court. In Vermont, that court's called the Vermont Supreme Court. Do you understand that you have that appeal right as well?
I understand.
Any questions at all, Mr. McClellan, about any of these rights that I've gone over with you?
No, sir.
Now, do you understand if you do plead guilty today, you'll be giving up these rights that I've gone over with you, including your right to a trial by jury, because there will be no further trial of any kind in your case.
I understand that, sir.
Has anyone used any force or made any threats against you to get you to go along with this agreement?
No, sir.
Has anyone made any promises to you to get you to do this other than what we've discussed today on the record?
No, sir.
Are you doing this today voluntarily?
Yes, sir.
I need to ask, are you currently under the influence of alcohol, drugs, or prescription medication such that you do not understand these proceedings here today?
No, sir.
Any reason you'd be having any difficulty understanding these proceedings today?
No, sir.
I need to tell you that if you are not a U.S. citizen, this agreement could result in your deportation, denial of U.S. citizenship, or denial of re-entry into the country, okay? Now, for the charge that you're pleading to today, I need to go over with you the maximum potential penalty, any mandatory minimum penalty, the nature of the charge, and the factual basis for the charge. So the potential penalty for this charge is a term of imprisonment of not less than 2 years, nor more than 15 years. In addition, fined not more than $5,000 or both. Do you understand that?
Yes.
And the nature of the charge is that at Wallingford on or about November 25, 2013 to November 24, 2018, you willfully and lewdly committed any lewd or lascivious act upon or with the body or any part or member thereof of a child under the age of 16 years with the intent of arousing, appealing to, or gratifying the lust, passions, or sexual desires of such person or of such child. That's the nature of the charge. Do you understand that?
Yes.
I'm going to ask the state to put the factual basis for the charge on the record, and I'm going to ask you to listen carefully, Mr. McClellan, because I'm going to ask you if you agree with those facts.
Thank you, Judge. On or between November 25th of 2013 and November 24th of 2018, the defendant Daniel McClellan was living at 3477 Route 140 East in East Wallingford, which is in the county of Rutland. The defendant lived at that address with his then girlfriend and her juvenile child, E.E., date of birth 11/25/2006. During that time period, around the time that E.E. was 7 to 10 years old, the defendant, acting willfully, lewdly committed a lewd and lascivious act upon her body by touching her breasts with his hands and kissing her breasts with his mouth. She was under 16 at the time. The defendant did this with the intent of arousing, appealing, or gratifying his own lust, passions, or sexual desires. That behavior was lustful, indecent, and sexual, offending current morality in Vermont.
Thank you. Mr. McClellan, do you agree with those facts?
Yes, sir.
To that charge, what plea would you like to enter?
Guilty.
All right, court will accept your guilty plea, find that there is a factual basis. Court will find that you've made your plea knowingly and voluntarily with full knowledge of its consequences and that you've waived your constitutional rights, and the court will enter adjudication of guilt. We will send for sentencing hearing approximately 6 weeks out for 30 minutes, and the court orders a pre-sentence investigation. Thank you.
Thanks. Watson.
Okay, next case. We don't have Attorney Hart yet, do we?
Shoot me an email.
Okay, thank you. Don't have Attorney Enzor.
You're not, I did look.
Yep.
It was just the two.
Okay, well, we'll come back to Sean Palmer, see if we do get Attorney Enzor. State versus Nicholas Pecor, 25 CR 97 92 43 97, 24 CR 1028 10124 63 64 1199 588. Attorney Brooks represents Mr. Pecor, Attorney Sun, and Attorney Walco representing the state.
This is Nicholas Pecor, Your Honor.
It is.
So I would say that substantial progress was made this morning in the form of a new offer relayed by the state. I've not yet had the opportunity to relay it to Mr. Pecor. It does entail some period of actual incarceration, so I don't want to say that we have an agreement yet. I think it might make sense at this point to have another status conference in short order with must appear with an eye towards potentially doing the plea.
Attorney Sun or Attorney Walco?
Judge, I have no objection to that.
Okay. So we'll set it for a status conference. If we can do it in 2 weeks or so, we'll try for 2 weeks with his participation required. Thank you. Versus Kenneth Hiller, 25 CR 12572 12660, Attorney Groff and Attorney Walco. Attorney Groff, how about Mr. Hiller's cases?
Yes, Judge. So I have received discovery on 25 CR 126600. I have not yet received it on the other case though. My request at this point would be another status in 45 days for me to get that and review it. I think we'd be ready for an FSO then, but this is only our first status, so.
You're welcome.
I think that makes sense.
Okay, that's what we'll do. Thank you. Versus Stephen Patello, 25 CR 13661 12937 13233. Mr. Patello is present with Attorney Falcone, Attorney Walco representing the state.
And Judge, we're working out an agreement as we speak. If we could circle back to these cases.
Very good. That's what we'll do.
Thank you.
Judge, if I could briefly interrupt, is Miss Templeton in the courtroom?
Yes.
If we could take her matter up, I think she's been sitting there a while.
Sure, come on up. State versus Tracy Templeton, 25 CR 13927, 25 CR 13946. Ms. Templeton is here. Her case is set for a status conference. She's represented by Attorney Groff. Attorney Bevere represents the state. It says though this is our first status conference. Attorney Groff.
Yes, Judge. I've reviewed the discovery in both of these cases, and I'm set to meet with Ms. Templeton tomorrow. My request is going to be a status in 30 days to see what her and I decide we would like to do with the case tomorrow, and see what we can work out before another status conference.
Attorney Bevere.
Fine, Judge, thank you.
Okay, that's what we'll do. Set another status conference in 30 days. And I understand you've got a meeting with your attorney tomorrow. Thank you.
Thank you, Judge.
You're welcome. Okay, let's see. Okay, we do have Attorney Hart.
I am back,
For the
yes, Your
record,
Honor. Thank you.
Thank you. State versus Lena McCurrier, 25 CR 1884. Attorney Hart representing Ms. McCurrier. Attorney McCowan for the state. Just see if I have any notes.
So if the
Do
court
you
would
have-
like, Your Honor, I can get you up to speed on where we're at.
Yeah, go ahead.
Thank you, Your Honor. So I filed a plea agreement with the court. It's going to need to be set for a change of plea. I think, given the allegations, probably at least a 30-minute to get through the process. And then we'll need a PSI ordered. If we want to order that now, that's fine. And we're probably going to need it set for at least a half a day sentencing. I don't think we're going to be able to do it in less than that.
Okay. Sounds like that's the agreement, Attorney McCowan.
That's right, Judge. We actually haven't, we did not, the prosecution did not sign the agreement yet, so we can refile that with this, with either mine or Mr. Keene's signature.
Okay, thank you. Okay, well, let's just do it one step at a time. So we'll set it for a change of plea hearing for 30 minutes. Then the court will order a PSI and then we'll set it for sentencing here.
Very good. Thank you, Your Honor.
Okay, thank you, folks.
Thank you.
Versus Kimberly Sherwood Kelly, 25 CR 5544418. Attorney Ferland and Attorney Falcone for Ms. Sherwood Kelly. Attorney Sullivan for the state. So I've got a note from February 6th. Defendant is incarcerated in Caledonia case. There has been an outstanding offer in our case for some time, set for status conference in 2 weeks to see if there is a resolution. So it looks like I've got Attorney Ferland and Attorney Sullivan. Somebody want to let me know if there's a resolution or not?
To the defense. I guess from my perspective, unfortunately, Attorney Falcone has been taking the lead on this. I have one case and she has the vast majority of them. So I did have a email exchange with her 10 days ago on the 13th, and
Let me just check. Attorney Davis, do we know where Attorney Falcone is?
She's reviewing the plea agreement with Tello at conference.
Oh, yeah, thank you. Yep. Yeah, we need, I'm sorry, my apologies. We need to wait for Attorney Falcone.
Okay.
Okay, thank you. Versus David Sparks, 26 CR 116 749 748, 25 CR 13395 13223 11488 and 10846. Sparks is here with Attorney Brooks, Attorney Bavir, representing the state. I think he's got some older cases and some that were just recently filed. Attorney Brooks.
Correct, Your Honor. There are a total of 7 cases. The oldest one is the felony, and that would be 25 CR 10846. Sure that Attorney Bavir and I can get an FSO in within a week. That sounds okay with the state?
Yes, Judge, that's fine. Thank you.
And I don't know if the state has heard anything from Mr. Madison regarding conditions of release and the no contact order.
We'll have to chat about that, Jamie.
Very well. I'll give you a call.
Okay, parties will file a felony discovery order in 25 CR 10846 within 1 week, and we'll have the misdemeanors track felony for now. Thank you.
Your Honor.
Thank you. Versus Jeffrey Springer, 1095805. RDCR 681-605 RDCR 1264-95 RDCR 1180-804 RDCR 509404 RDCR. Attorney Davis here representing Mr. Springer. Attorney Sullivan representing the state. Mr. Springer's participation was required today. Let me just look at, I've got a note from January 20th. The defendant participated today remotely as required. He resides in Kentucky. Arrest warrant is struck. Defense requests further status conference in all cases in 30 days. So do we have Jeffrey Springer?
I did not see him on the WebEx.
No? Okay. Anything to report, Attorney Davis?
So this is one where admittedly I had intended to set aside a block of time to have a phone consult with Mr. Springer about the nature and circumstances of these very old cases that just came back up. I did not do that. Other things just took precedence, I suppose. So I will say I was out of the office this morning for a period of time, but I have 2 voicemails from him returning. He actually reached out today. And then I left him a message and he left me another message. So his contact information appears to be good. I don't know what the issue was with him not signing on for whatever reason, but I certainly imagine in fairly short order I can get in touch with him. I just need to have that phone consult so that I can approach the state with our thoughts about what to do here, or whether we just need to put in place a scheduling order that gives me some time. But given the somewhat unique circumstances of these cases, there may be a fast track to resolution depending on what they actually look like. So I'd ask to reset this. It's depending on what my schedule is, in 2 or 3 weeks. I'm sure I could get out in front of this. I just didn't in advance of our status today.
Attorney Sullivan?
I think that makes sense. These are obviously old I believe they're all VOPs if I'm tracking this correctly.
I think there are
there's new
some cases and
are very old cases that aren't VOPs. Yep.
Okay, yeah. I'm
Okay.
hopeful that we can get our arms around this quickly, but maybe a status in a week or 2.
Okay. All right, we'll do our best, set it for status conference in 2 weeks. We will require his participation.
I will relay that.
And the state's okay with that being by WebEx?
And be remotely. Thank you. State versus Sean Palmer, 25 CR 13965. Attorney Enzor represents Mr. Palmer. Attorney Walco represents the state. So looks like this is a brand new assignment for Attorney Enzor. I'm not even sure if he received notice that he's representing Mr. Palmer. Attorney Enzor, do you know anything about this one yet? Sean
Well, Judge,
Palmer?
thank you, Judge. It is a brand new assignment, and I apologize, but what's the docket number again?
25 CR 13965.
Okay, so it's a relatively late case in 2025.
Yeah.
I would suggest, if the court's okay with it, setting it for pretrial in June with July draw.
Well, we don't do it like Bennington, remember, we all do it in the same, we do it in the same month. So if you want a July trial, it'd be a July pretrial as well.
Yeah, that's fine. I appreciate that. Yeah, that's fine.
Hey, Walco?
So July pretrial,
Yes.
I have no objection to that. I'm not sure if I'll have all the discovery back. I believe this is a drug case. However, I don't know if it makes sense to put a status on before that, or
You don't think you'll have all the discovery in time for a July trial?
it depends on the lab results, Judge. I'll find out a rush and hopefully I will. We can address it at the pretrial if necessary.
Okay. Yeah. I didn't realize it took that long from the labs, but apparently it does. So,
yeah.
okay. All right. Okay. Well, we can address it at the pretrial if it's not ready. But we'll put it on the July pretrial and jury trial. Thank you.
Thank you, Judge.
Judge, can I just check? I think I'm all set for this afternoon. All the statuses that would have been on for this morning, those are just being rescheduled. Is that right?
Yeah.
Okay.
Yeah. I've got you on Natalie Zilski.
Oh, that's right. That is the.
So let's do that one. State versus Natalie Zilski, 26 CR 637, 24 CR 1969, 24 CR 4531. Attorney Davis and Attorney Berlin and Attorney Walco for the state. So we've got an evaluation from Dr. Poole, who opines that the defendant is not competent to stand trial. Attorney Walco, what's the state's position on competency?
Judge, I just received the report a few days ago. I would be seeking a short period of time before putting a position on the record.
Okay, set it for a status conference on competency. Attorney Davis?
Yeah, so there's a couple of ways I think we can do it. We're already scheduled for a hearing on Wednesday because I filed a motion to suspend the whole the bail so that she can go to residential treatment on Friday.
Okay.
We can check back in if the state still needs additional time, perhaps a status. I think we're going to have a stipulation regarding her release to residential treatment.
Okay.
So in light of that, my concern about the 21-day window, if there is a finding of non-competency, goes down because she's going to be released to treatment. So I think we can go forward with the hearing on Wednesday in the other dockets and check in at that time. And if the state needs additional time, understanding our stipulation, I don't suspect I'll object to them.
I think that sounds good, Judge.
Okay. Attorney Ferlin?
I don't have anything to add, Judge.
Okay. All right. So we'll status it again on Wednesday, see if the state has a position on competency or if we've got to do something further at that time.
Okay.
Okay. Thank you. Okay. State versus Kimberly Sherwood Kelly, 25 CR 554, 24 CR 4418. Attorney Falcone and Attorney Ferlin and Attorney Sullivan. Attorney Falcone, where do we stand on your case regarding Ms. Sherwood Kelly?
So Miss Sherwood Kelly is currently lodged at Chittenden. She wants to accept the state's offer that was made on her two Rutland cases. I think the only issue is we're still trying to figure out what's going on with her probation revocation cases in Caledonia County. I don't have an answer on that, and I don't think her attorney out there has an answer on that yet. However, what I would suggest is setting a change of plea in about 45 days, and hopefully we'll have a better sense of what's happening. She's not being held on our cases, so I don't think she'll be if she's able to be released, then it won't be us having a change of plea in 45 days that'll hold her.
So in all likelihood, is she still going to be incarcerated in 45 days? Do we have to at least try set up a video or transport order?
Let's set up a video, just in case.
Attorney Sullivan?
That sounds like a good path forward.
Okay, set it for a change of plea. Video if she's still incarcerated in approximately 45 days. Okay, thank you. Okay, I think that's all of them except for Mr. Pillar. Is it Mr. Pillar? Was that?
No, Mr. Patello, you have the paperwork signed. You want a copy?
We got it.
Okay, so I can.
Let's stay for the change.
Okay. Otherwise, I think we've gone through our entire list. Thank you, everybody.
Yep, I will. Thank you. And Judge, I do have two amended informations as part of this plea agreement. I have them drafted. I'm just getting them filed as we speak. I did just have Attorney Falcone take a look at them.
I didn't catch the last part. Has Attorney Falcone received him yet? Are you? Okay,
yeah.
so we can go ahead and arraign him on the amended
We
information.
can, yes. So for the amendment in, let's here. In 25 CR 12937, that's an amendment to negligent operation. We are in receipt of the state's amended information. We would waive formal reading of the charge of Rule 5 and 24-hour rule, enter a guilty plea pursuant to the agreement. And with the amendment in 25, well, the he hasn't been arraigned, so it's on 25 CR 13661. We are in receipt of the amended information. We would waive formal reading of the charges of Rule 5 and the 24-hour rule. Pursuant to agreement, Mr. Patello will enter a guilty plea to the amended count 2, possession of cocaine greater than 2.5 grams.
Okay, so Mr. Patello, is that what you want to do here today?
Yes, Your Honor.
So I'm going to go over the agreement with you as well as your rights to make sure you understand everything as we go through the process. If you do have any questions, speak right up and let me know. And also feel free to talk privately with Attorney Falcone at any time. According to this agreement, you're going to plead guilty to the amended charge in 25 CR 13661, possession of cocaine in excess of 2.5 grams. As a result of that guilty plea, you're going to receive a 2-year deferred sentence. In 25 CR 12937 to the amended charge of negligent operation of a motor vehicle. You're going to plead guilty, receive a sentence of 0 to 3 months, all suspended, placed on probation, concurrent with your other case, term of probation to be years. The remaining charges will be dismissed pursuant to the agreement. Is that your understanding of the agreement?
Yes, Your Honor.
Have you had enough time to go over this agreement with your attorney?
Yes, Your Honor.
Have you had enough time to review the proposed probation conditions with your attorney?
Yes, Your Honor.
Are you satisfied with those conditions?
Oh, yes, Your Honor.
And I'm sure Attorney Falcone reviewed with you what it means to receive a deferred sentence. I'm going to go over some of the aspects of it as well. So you're going to be on the possession of cocaine charge. You're going to be put on probation for 2 years. If you successfully follow the terms of your probation and don't get in any further legal trouble, at the end of that probation, that charge is dismissed and the record's expunged. So you'd have no record at all. On the other side of it, if for some reason you weren't successful on probation, the state could bring a charge against you called violating the terms of your probation. You could oppose that and have a trial, but it would be a trial just in front of a judge, not in front of a jury. And if the state succeeds, then you could lose the benefit of the agreement and be sentenced under the possession of cocaine conviction. You understand all that okay?
Yes, Your Honor.
Any questions about any of that?
No, Your Honor.
Now, you understand you don't have to plead guilty today if you don't want to. You do have the right to continue with your not guilty plea and to have a trial if that's what you want. You understand you have that right.
Yes, Your Honor.
You also have what we refer to as the right to remain silent, meaning you couldn't be forced to testify or give evidence against yourself, and you have the right to be represented by an attorney throughout these proceedings. And if you can't afford one, one will be provided to you by the state. Do you understand that?
Yes, Your Honor.
If you continued with your not guilty plea, you'd be entitled to a trial. You could have a trial either in front of a 12-person jury or just in front of a judge. That would be your decision to make. But at any trial, the state would have to prove you guilty by beyond a reasonable doubt. And at a jury trial, all 12 jurors would have to unanimously agree on the verdict. You understand that you have those rights.
Yes, Your Honor.
Also, at a trial, you'd have the right to hear and see what the state's witnesses had to say and to have your attorney question those witnesses. Also, you could call witnesses to come to court to testify for your side. And if for any reason any of your witnesses did not want to come to court voluntarily, through your attorney, you could make sure they came to court and testified by having the court issue them a subpoena. Do you understand that?
Yes, Your Honor.
At a trial, you'd have the right to testify like any other witness, but as the defendant, you'd also have the right not to testify. And if you decided not to testify, then you wouldn't have to testify. You couldn't be forced to testify, and it could not be held against you in any way if you decided not to testify. You understand that you have that right as well.
Yes, Your Honor.
In addition, you'd have the right to appeal any verdict to a higher court. In Vermont, that court's called the Vermont Supreme Court. You understand that you have that appeal right.
Yes, Your Honor.
Any questions at all, Mr. Patello, about any of these rights that I've gone over with you?
No, Your Honor.
Now, do you understand if you do plead guilty today, you'll be giving up these rights that I've gone over with you, including your right to a trial by jury, because there will be no further trial of any kind in your case.
Yes, Your Honor.
Has anyone used any force or made any threats against you to get you to go along with this agreement?
No, Your Honor.
Has anyone made any promises to you to get you to do this other than what we've discussed today on the record?
No, Your Honor.
Are you doing this today voluntarily?
Yes, Your Honor.
I need to ask, are you currently under the influence of alcohol, drugs, or prescription medications such that you do not understand these proceedings here today?
No, Your Honor.
I need to tell you that if you are not a U.S. citizen, this agreement could result in your deportation, denial of U.S. citizenship, or denial of re-entry into the country. That only applies if you're not a U.S. citizen, but do you understand that?
Yes.
Now, have we received the amendments yet, Justine? Okay.
I have just pressed the button on the last one. I filed the other one about 30 seconds ago.
Oh, so since you filed them for all that's we won't even get them tonight. You have to.
You have to email them to Justine.
I can email them. They should be coming over to you right now.
Okay, so for the amended charge in 25 CR 13661, possession of cocaine 2.5 grams or more, that charge carries a potential sentence of a term of imprisonment of not more than 5 years or a fine of not more than $100,000 or both. Do you understand that? And the nature of that charge is that at Rutland City on or about November 11, 2025, you knowingly and unlawfully possess cocaine in an amount consisting of 2.5 grams or more. Do you understand that? And is it correct that on November 11, 2025, at Rutland City, you were knowingly and unlawfully in possession of cocaine in an amount exceeding 2.5 grams?
That's right.
To that charge, what plea do you enter? Next is the amended charge, negligent operation of a motor vehicle in docket number 25 CR 12937, carries a potential sentence of a term of imprisonment of not more than 1 year or a fine of not more than $1,000 or both. Do you understand that?
Yes, Rob.
And nature of that charge is that at Rutland on about November 20, 2025, you were operating a motor vehicle on a negligent highway, public highway in a negligent manner. Do you understand that?
Yes, sir.
And is it correct that on that date you were operating a Hyundai automobile on a public highway named Forest Street in Rutland, and you were operating in a negligent manner?
Yes, Your Honor.
And you understand that negligence means a failure by a driver to exercise ordinary care under the circumstances. Ordinary care is the care that a prudent or careful person would exercise under the same or similar circumstances.
Yes, Your Honor.
To that amended charge, what plea do you wish to enter?
Guilty, Your Honor.
All right, court will accept your guilty pleas, find that there is a factual basis. Court will find that you've made your pleas knowingly and voluntarily with full knowledge of their consequences, and that you've waived your constitutional rights, and the court will enter adjudication of guilt in this matter. Very welcome. Anything further from the state?
Judge, I would just ask that you accept this agreement. The defendant has a limited record, and while the drug charge is a felony, it was 3.2 grams, which is relatively amount given the circumstances. And as far as the reckless, the BAC was 0.085, not extremely high, which is why the state feels it's appropriate to amend it down. And the state believes that the deferred sentence is appropriate given the defendant's.
Thank you. Ray Falcone?
Thank you, Judge. Also ask the court to accept the agreement. The court would notice the dates of offense for the 3 dockets that we're here for today. All happened in November of last year. It was a very difficult time for Mr. Patello. His relationship of 17 years with his wife, with whom he has 3 children, was ending. Divorce was just finalized in January. So Mr. Patello was having a really difficult time self-soothing in unhealthy ways. But right after that, right after picking up these charges, he did enroll himself with Rutland Mental Health and has been getting the treatment that he needs. He's an IOP and he's doing really well. And I don't think that the court will see him again.
Thank you. Mr. Patello, anything you want to tell me before I impose a sentence?
No, Your Honor.
Okay, for everything, based on everything I've heard on the record, this is a fair and appropriate agreement. Gives you a chance to start putting this behind you and start looking forward instead of backwards. And also gives you a chance to be successful through any appropriate treatment as well.
Sure.
So court will accept this agreement. Amended charge, possession of cocaine, 2.5 grams or more, 2-year deferred sentence. Negligent operation, 25 CR 12937, 0 to 3 months, all suspended, placed on probation, concurrent for 2 years. Court will impose the agreed upon standard and special conditions of probation and dismiss the remaining charges pursuant to the plea agreement. So you're all set, Mr. Patello.
Thank you.
Good luck to you.
Thank you.
If you could check in downstairs before you leave and get your paperwork. It's too late in the day to go over to probation today, but I don't know if you have time tomorrow to do it.
Yeah, I should be able to do it.
Okay.
See my children tomorrow at
Yeah.
3:30, but I should be able to get it done before then.
Sounds really good. Okay, great. Have a good day. Thanks, everyone. Be in recess.
Judge, Judge,
Yes.
I'm sorry to
Mr.
interrupt.
Yeah.
Did the court cover Tracy Benoit earlier today?
Yes.
I had that on my schedule.
Oh. Yeah, sorry. Mr. Benoit was here, so I didn't want him to have to stick around. So I said we would reset it for 30 days.
Okay, that's fine. Thank you.
Okay. Should have spoken up sooner. You didn't have to wait all that time.
Well, I had to go back to
Comfortable.
I had to go back to Bennington and so as comfortable as I can be. Yes, thank you.
Okay. Good. Okay, very good. Thank you.
Thank you, Judge.
We'll be in recess.
Well,